Hi, I'm TaxMax. Let's break down today's tax topic.
Here's a tax fact people underestimate. HMRC doesn't need to open an inquiry to start checking your tax. Submitting a corporation tax return does not mean everything is automatically accepted. HMRC has statutory powers to check whether a company's tax position is complete and correct. These powers exist to protect the tax system and apply to all companies, regardless of size. HMRC can review a company's tax position in two main ways: by opening a formal inquiry into a corporation tax return, or by carrying out a compliance check. An inquiry is a formal legal process tied to a specific return. A compliance check is broader and more flexible and does not need to relate to a particular return. In recent years, HMRC has increasingly used compliance checks instead of inquiries. A formal inquiry is an official investigation into a company's corporation tax return. An inquiry can be random, routine, or triggered because something appears unusual. If a return is filed on time, HMRC normally has 12 months from the actual filing date to open an inquiry. For large groups, the deadline runs from the filing due date instead. If a return is filed late, HMRC has at least 12 months, and the deadline moves to the next quarter day. The quarter days are 31st January, 30th April, 31st July, and 31st October. If a return is amended after the filing deadline, HMRC gets extra time to inquire into the amended items. This does not reopen the entire return. A compliance check is any action HMRC takes to check a tax position without opening an inquiry. This includes asking questions and requesting documents. HMRC has wide powers to request information reasonably required to check tax. This includes electronic records, such as emails. If informal cooperation fails, HMRC can issue formal information notices. Providing inaccurate information can lead to penalties of up to £3,000 per inaccuracy. HMRC may inspect business premises where reasonably required. Inspections normally take place with written notice and at a reasonable time. If a company fails to submit a return, HMRC can issue a determination. A determination is HMRC's estimate of the tax due. A determination cannot be appealed. The only way to replace it is to submit the correct return. HMRC may issue a discovery assessment if tax was missed, insufficient, or relief was excessive. Discovery is restricted if a return was filed correctly, unless behavior was careless or deliberate, or HMRC could not reasonably have been aware of the issue. A discovery assessment cannot be raised where the return followed the practice generally accepted at the time. Time limits for discovery are 4 years normally, 6 years for careless behavior, and 20 years for deliberate behavior. Corporation tax figures eventually become final. Finality is reached after specific statutory time points, after which figures cannot usually be revisited. Understanding HMRC's powers helps companies manage risk and avoid surprises. Why did HMRC bring a magnifying glass to the meeting? Because the details really matter.
Educational content only, not advice. Rules can change.